Oftentimes complainants they go to a hearing and the judge will take action, and they're so upset that as they're going home, they're on the phone with the commission. How can I file a complaint against the judge? And those are decisional issues. There's nothing that we can do. And if they don't follow the law in that one instance, they have to appeal. They're upset, and we certainly understand that. And it just didn't rise to the level. We have a clear and convincing standard. It's a very high standard. We have to prove these cases. We can't just receive a complaint and then file formal charges. There is a process, and there is a legal process, and it's long. But I also, the commission is very mindful of the public, and there are cases and conduct that has occurred that should not have occurred. Judges should know the law. They should be diligent. If you're a judge, that's your job. Now, there is a process. If they don't do that, mistakes are made. Just because a judge doesn't follow the law in one instance doesn't make them a bad judge. Every judge has had cases reversed, and it doesn't make them bad judge. It's just, and I can tell you 95% of the time, they learn from that.
Hello and good morning, everyone. Welcome to this October 23rd, 2021 session of the Our Nevada Judges Perspective Series. Today we have the Nevada Commission on Judicial Discipline, a primer for parties and practitioners. We're here in the wonderful worldwide digital broadcasting studio. Today we've got Executive Director Paul Deyhle. He's Executive Director of the Commission on Judicial Discipline. I am Alexis Brown. I'm a solo practitioner. I sit on a couple of boards, and I am super excited to be here and feel very privileged to have Mr. Deyhle with us. We will have some announcements somewhere in the middle of this, but that'll come up as a little bit of an announcement section. But we'll get right into it with Mr. Deyhle. Mr. Deyhle, please just tell us a little bit about yourself. What was your path to becoming Executive Director of the Commission?
Well, again, thank you for inviting me. I look forward to speaking on the Judicial Discipline Commission. I joined the Commission on November 1st of 2013. I came from a private practice. I was a partner with McDonald Corona Wilson Law Firm for several years, and joined the commission in 2013.
And what made you decide to take that role on?
Well, I was looking for something different, and I wanted the challenge of running my own organization, and there was a lot of personal and professional reasons that I can't sum up during this, but it was a difficult decision, but one that I'm very happy that I made.
Sure. It's an important role, obviously, in our community, this commission. So what do you do as executive director? Like, how would you describe your position?
Well, it's a dual purpose. I'm the executive director of the commission, so I handle all the administrative matters, budgeting, appearance before the legislature, requesting funds, hiring, firing, anything that an executive director of a Nevada state agency is responsible for. That's what I do for the Nevada Commission on Judicial Discipline. The second role is general counsel. So I advise the commission on judicial misconduct complaints that are received. And I can go into more detail on what that entails, if you would like.
We'll definitely get into that for sure. We'll be getting into a lot of that. Just before we get into that, though, what is the role of the commission itself then? So we've got the commission. What is its role, and where does it get its authority?
Well, the purpose of the commission is to protect the public. That's the overarching purpose. And we are a discipline commission, so the commission does discipline judges, but the primary purpose is to protect the public, and we do that by means of disciplining for misconduct. It's not just disciplining judges. There's other avenues that the commission addresses misconduct, which I can get to later as well, but primarily that's its purpose.
And there's commission members, and then there's also a committee, right? So maybe you can
Yes.
tell us about sort of the structure and how the commission is made up.
Well, we have the Commission on Judicial Discipline, and then we have the Standing Committee on Judicial Ethics. So the Standing Committee is a sister organization of the Commission. It falls under the same umbrella, organizational and budget umbrella, if you will, of the Commission. So I am also the executive director of the Standing Committee on Judicial Ethics. I'm not general counsel to the Standing Committee, but I handle all the administrative matters, setting up panels with my staff, of course, and the Standing Committee issues advisory opinions on ethical matters that judicial candidates and judicial members have. And they issue non-binding advisory opinions. The Standing Committee also assists the Supreme Court from time to time on changes, prospective changes to the code and other laws and rules that govern the Commission.
A lot of different stuff. So as far as the commission goes, how are commission members chosen? Maybe tell us a little bit how it's, the structure of that commission individually, how it's made up, and how the commission members are chosen, and who's currently on it.
Well, let me, before I go on, I just want to tell you that on our website, we have a very detailed website. It's split into Judicial Commission, Discipline Commission, and the Standing Committee. And we have all the rules and laws that govern the Commission and the Standing Committee. We have various links. So, to those who would like to familiarize themselves with what the Commission does and what its authority is, and the Standing Committee, it's a great resource, a good starting point to get familiar with it. As far as how the makeup of the Commission, the Commission has 7 regular commissioners. 3 of those commissioners are laypersons, and they are appointed by the governor. There are 2 judicial district court members, and they are appointed by the Nevada Supreme Court. And there are also 2 attorneys who are appointed by the State Bar Board of Governors. And we also have alternate commission members, lay, judicial, and an attorney. And those are appointed by the same appointing authorities, and they step in the place of a judicial commissioner, if there's a conflict of interest or if a commissioner cannot serve for whatever reason. So there's quite a long list of lay people, attorneys, and judges throughout the state in different jurisdictions, and their names are on our website, both on the commission side and the Standing Committee side.
Fantastic. So we'll make sure that our viewers get that link for your website to make sure that they can go and check out all of the people who are currently serving on the commission. Are the alternates also listed on the website?
Yes, they are.
Fantastic. And it has little bios, I would assume, of who they are?
No bios, just the names of the commissioners and Standing Committee members.
Fantastic. So how long do the commission members serve on the commission? What are their terms?
There's a 4-year term, and after the 4 years, once the term expires, then they have an opportunity to be reappointed by the appointing authorities. And there are no term limits for the commissioners. So it's really up to the appointing authorities to determine if they're going to reappoint existing members or appoint new members.
Is there some kind of application process for each of these appointing parties to get on the commission, or how does that work?
Yes, each appointing authority has a process. And typically it is on their websites, or they can call the Supreme Court, the AOC, Administrative Office of the Courts, the State Bar, or the Governor's Office. But typically they have sections on their website that deal with the commission openings, not just with the Judicial Commission, but all the commissions and committees throughout the state.
Gotcha. How many judges does the commission oversee at this point? And that may be a loaded question because you oversee more than just judges when people think of just like district court judges or something like that, right?
Yeah, the commission oversees over 600 judicial officers. Okay, so those comprise district court judges, limited jurisdiction judges, which are your municipal court judges, justices of the peace, also hearing masters and pro tem judges, commissioners, referees. So the definition of judicial officer or judicial member is quite, large.
Yeah.
And it also includes during election years the judicial candidates. So during election years, we will have judicial candidate. Well, let me back up. So judicial candidates can be subject to the commission by virtue of their campaign activities. Okay, so if they become a judge, then and they've committed, say, a campaign violation, or they violated Canon 4 of the code, and they are elected to be a judge, then we would have jurisdiction over them. If they don't have, if they're not elected, then the state bar would have jurisdiction for conduct under the professional code. So.
Interesting. So that is because once someone applies or puts in their submission to be a judge, they automatically become subject to the canons at that point. Isn't that right?
Well,
or some of them.
Once they're in the election process, a campaign process, then we don't have jurisdiction over attorneys or others that are candidates for office. It's only when they become a judge.
Okay.
And they have committed a violation of the code during that process would we have jurisdiction. So, if say an attorney is running to be a judge and there was some campaign violations, violations of election law, and they do not become a judge, were not elected, then the state bar would have jurisdiction if they so choose to follow up on that with the attorney, but we wouldn't have jurisdiction at that point because they're not a judge.
Got it. And I guess so that maybe segues a little bit into another question I have about the role that the state bar plays once someone is a judge. So you mentioned jurisdiction. Does the state bar lose jurisdiction over judges once they're elected to the bench?
Well, this topic has come up quite a bit, and there's differences of opinion. As for the commission, as I said, we cannot discipline a judge for conduct committed when that individual was not a judge, say as an attorney. We cannot. Our statutes, our rules are very specific on who the commission has jurisdiction over, and they simply have no jurisdiction over anyone unless you're a judge, okay, for conduct prior to becoming a judge. The only exception being is what I said,
for campaigns.
Campaign conduct, misconduct.
Okay.
That is the only exception. As far as the state bar and whether they would have jurisdiction over attorneys who became judge for misconduct prior to becoming a judge, I would think they would have jurisdiction because the conduct occurred prior to becoming a judge. But I'm not an expert on the professional rules of conduct, and I would follow up with the state bar on that. The commission has the ability to refer cases to the state bar, which again lends credence to the point that the state bar would have jurisdiction in certain matters. As I said, the state bar could not step in and discipline a judge for actions committed as a judge, okay? Because the commission has sole and exclusive jurisdiction over judicial misconduct, okay? If presumably, and I'm just saying presumably, the state bar could discipline attorneys who have become judges for conduct that occurred while they were attorneys. But again, I don't want to I'm an expert on Judicial Discipline Commission and its rules and procedures. Not necessarily. I'm very familiar, of course, with the professional rules of conduct. I have to be, but in terms of these types of questions, jurisdiction over attorneys for misconduct who become judges, I would defer to the state bar because they have jurisdiction over that area.
Sure. Well, maybe at some point we can get someone from the state bar in to talk about those things. I would love to have our counsel for the state bar come in as well. So again, then the question becomes, you then are responsible, once they're judges, to, if they are violating rules of professional conduct, that may be something that the commission would look at that point.
Yes.
Got it. So how then does a complaint start, and who can make them?
Anyone can file a complaint. A litigant in a courtroom, a member of the press, a judge can file a complaint against one of their colleagues. Anyone in the public can file a complaint with the commission. And
how would someone go about filing a complaint with the commission?
Well, they would go to our website and they can download or print out a form. A complaint form. They would fill it out, and then they would mail it into the commission, and then that process would start.
And then what are the next steps? Like, once it gets to you guys, what do you do once you receive a complaint?
Well, we review the complaint and any other information that's been provided. We will, for example, if a complaint is alleging misbehavior on the bench or something of that nature, then we will order videos of the courtroom proceeding. So we would contact the courts throughout the state and order videos and or transcripts to take a look at those proceedings. And then counsel, legal counsel for the commission, myself and an associate general counsel, will prepare recommendations to the commission. And those recommendations, they summarize the facts, the law, and we have a conclusion, or whether the counsel believes, under the circumstances, under the facts and the law, that the case should be investigated, it should be dismissed, whether a letter of caution should be issued. So that is that process. And during that process, they also, the commission sees the complaint and all of the supporting documents that are filed along with the complaint, or anything that the commission staff pulls during that process. That also includes and I can get into the entire process later on in the interview, or if you want me to do it now, just let me know.
Yeah, you can get into it, please.
The commission sees everything that legal counsel and staff sees. They when they convene for their meetings, they have access to everything. So, but they also have our recommendation that summarizes the facts and the law.
Sure. So it sounds like you and as counsel and staff, you do some preliminary investigations yourself about whatever it is that has been complained about as well, right?
Well, very limited, and it's confined to getting a video from a court or a transcript. The staff does not investigate or start an investigation without the commission authorizing that investigation. So just so the commission, when they meet and they're reviewing all of these materials, they have all of the information before it to make an informed decision. So as I said, if there's a complaint alleging that that a judge acted inappropriately on the bench, said things that were inappropriate or what have you, it would be helpful to have the videos. So that's all the staff does, is they request those videos. We have statutory authorization to do so. Or those transcripts, we upload those to the commission when they review for the next meeting, so they have access to it and they can review it themselves.
So you said you give your recommendations, and then the commission meets and considers the evidence and then makes a decision to either follow your recommendation or do something different?
That is correct.
Okay.
Yes.
How does the commission sort of generally follow your conclusions, or do you sort of get overturned, so to speak?
Well, yeah, sometimes they follow the recommendation and sometimes they don't. And that's the way it should work. It's just a recommendation, right? All 7 commissioners are independent. They're judges, lay people, and attorneys, and they are charged with making the decisions as to whether a case is dismissed, whether it goes to investigation, whether a judge responds to a complaint, or whether the complaint is, there's public charges filed. So I believe that's the way the system should work. It's merely a recommendation, and they can follow that recommendation as they see fit or not.
And with 7 people on the commission, is it sort of by a majority vote, or what kind of voting occurs to make the next steps?
So it's a quorum. So 4 commissioners out of the 7 have to decide whether a case is going to move forward or be dismissed or go to public charges, et cetera. So now the only exception to that is during the public process. Once formal charges are filed, if they are filed, we need 5 commissioners to impose discipline.
Okay, makes sense. So it sounds like, so there's sort of this initial process. It goes to the commission to make a decision as to either, you said, dismiss it or what were the different options, I guess, other than dismissal? What are the other options that the commission might take?
Well, if I may, I can run through the process.
Sure.
There's a confidential process, and then there's a public process. Okay. So the confidential process includes reviewing the initial complaint, okay, and they decide whether a complaint's going to be dismissed. If it is dismissed, then there's nothing further to action to be taken on the complaint. If they can also decide to issue a letter of caution under the circumstances. Letters of caution are not considered discipline. They're not made public. It is simply a letter to the judge to remind him or her that this is, this particular case, the commission found X, Y, and Z, and it's just kind of a nudge to inform them of what they may or may not have, what they could do better in the case, and some of the concerns that we had, but it didn't rise to the level of going forward to public charges. So that is an option that the commission has at each level, whether it is before an investigation, after investigation, and even after having the judge respond. The next step in the process is whether the commission is going to authorize an investigation. So if they do authorize an investigation, then it'll go to an independent investigative firm. We don't do the investigations in-house, so it's an independent investigative company that will do the witness interviews, interview the judges, and then they will prepare a report. Again, the same process. So, they'll submit that report to the commission. Staff, counsel will review that report and then again make recommendations for the next meeting as to whether the investigation was, substantiated the allegations in the complaint. If they do, then it goes on to the next phase. If they don't, then it's dismissed, or as I said before, a letter of caution could be issued. The third phase of the confidential process is to have the judge respond to the complaint. Again, this is not a response that's public, it is confidential. And under law, the judge has to submit a response to the allegations in the complaint. And before they do so, the commission will send a letter to the judge explaining, why they have to respond. They will, the judge will get a copy of the complaint and any other supporting documents up to that point, and will also get the investigation report and the transcripts of the investigation report. So everything that the commission used in determining that the commission should investigate, and the results of that investigation is provided to the judge before the judge is asked to respond. And once the judge responds, again, process starts again, and a recommendation is prepared after the counsel reviews the response. And then a recommendation is made to the commission as to whether, the case should go to public charges or should be dismissed with or without a letter of caution. So that is the confidential process of the judicial discipline. And the next process, of course, is the public process. Okay, so if the commission does decide to to have formal charges prepared, then again we have a independently licensed attorney called a special prosecutor or a prosecuting attorney who will review all of the documents and will prepare formal charges. So again, as counsel, we don't try the judges. It is again left to independent counsel to do so. And that process goes forward just like any other legal court case. There's hearing, there'll be a chance there'll be motion practice. The discovery is limited to the judicial discipline investigation process. And there's reasons for that. And these reasons were developed over decades throughout the country. When these judicial discipline commissions were formed, these issues were developed. So discovery would consist of the investigation, interviews, so the judge would sit down with an investigator as well as witnesses, and all of the information that is provided that the commission gathers in that process, as I said before, is given to the judge prior to the filing of formal charges. So the judge essentially has everything that the commission has prior to going to trial, and even prior to that, to answering the complaint. But as you know, litigation takes a long time, takes years potentially for a case to go to trial. And when these commissions were formed over decades throughout the country, decisions were made that discovery would be limited in that process, so decisions can be made in an expeditious matter of circumstances.
Sure. So just a limited discovery. Is there depositions that they take of, the investigator, the witnesses? They can do that limited a bit, and then.
Yes, they have to ask for leave of the commission or permission for the commission to do depositions, and the commission has approved that in certain circumstances, and other circumstances no. It really just depends on the case and the particular circumstances of that case.
And then once we've done our discovery bit, then we get set for trial, a trial hearing?
Yes.
Okay.
Yes.
And who, the hearing occurs before the members of the commission? Is the 5 panels? You said you had to have at least 5, right?
Well, no, it's all 7. It'll be 7 commissioners.
Okay.
And as I said before, to impose discipline under the law, you have to have 5 commissioners agree to that discipline.
Okay. So they have a trial in front of all 7 of the commissioners, and then they will listen to all of the evidence and argument and make their final decision. And at that point, what are the options?
Well, if the prosecuting officer has proven the allegations to the satisfaction of the commission, then the commission would impose discipline at that point. And if the prosecuting officer did not prove certain allegations, those allegations would be dismissed. So this prosecuting officer has to prove his or her case before the commission, just like any other case in court.
I was going to ask, what is the level of burden of proof for the prosecuting officer? Obviously in criminal, we've got beyond a reasonable doubt, sort of beyond a preponderance. What is the burden that the prosecuting officer has in these kinds of cases?
Under the law, it's clear and convincing evidence. So, of the scale, you have at the top, like criminal, you have beyond a reasonable doubt. And then just below that, it's clear and convincing. So it's an extremely high standard, but not as high as criminal.
So at what point, so we've got a level where now a judge has maybe been disciplined. What are the next steps that might have to be taken for a judge to actually get to the point of being removed from the bench?
The point, well, you mean after the trial?
Well, I guess that's the question is, can the discipline maybe go up to the level of being removed? Or, what levels of discipline are there that the commission could impose?
Well, there's a wide range. It can be public reprimands, censures, or admonishments, and these are defined in the law on what those are. Particularly, the commission can issue fines, require public apologies from judges. They can suspend a judge with or without pay. The commission can order or require, in certain circumstances, evaluations, psychological evaluations, etc. So there's a wide range of remedies, depending, of course, on the case.
Interesting. What kind of, what sort of activity might get a judge really in trouble? You know what I mean? Because obviously people are filing complaints all the time. I would assume there's a lot of complaints you guys deal with. I know the numbers are on your website. The statistics of all of the cases that you guys get are on there. What kind of issues would get, to those next steps? Which ones are you actually disciplining judges for, rather than, and what would get a letter of caution? What would get a public reprimand? Those kinds of things. Do you have any examples you might be able to give without giving names, of course?
Well, yes. The more serious, and this is not just Nevada, but it's across the country, with examples of serious misconduct. It would be, embezzling money from the public. It would be, in certain circumstances, acting inappropriately on or off the bench, depending on the seriousness of those actions. Behavioral issues, not following the law, not complying with the law in certain circumstances. But a lot of these cases involve more than one violation. So it's typically not just one violation of the code. It's multiple violations taken together that may form the basis of a removal from office. There could be a circumstance where there was one incident and it was so serious that a commission would remove a judge, that has been the case at times in commissions throughout the country, but oftentimes it's multiple violations. When taken together, rose to that level.
And sometimes it's a series of issues that might come up, like say there's one discipline and a judge gets a letter of caution, and then the next time if it's confidential and say they get a letter of caution, but now the judge has more complaints, would that maybe influence a decision or a recommendation to escalate it maybe to a different charge or something like that?
Yes. So, typically if there's an allegation that was relatively minor and the commission decided to issue a letter of caution, and then the judge is continually doing that, then it certainly would be considered going forward to take next steps.
So when it's in this public phase, if there's public charges that have been filed, can the public come and watch the proceedings? How does that work?
Oh, yes. The public, all proceedings are public, and all the documents that are admitted into evidence during those proceedings are public documents, and so they're welcome to come and review and witness our proceedings.
And what about sort of recording by forum, sort of like our Nevada judges? How does the commission feel about us trying to get this out to more of the public?
Yeah, the commission welcomes that, to have electronic coverage, and we often get requests from your organization in the past, as well as other media organizations to record, and we have communication, as you know, during that process, and they're welcome. And there's rules that they have to follow. There can't be disruptions. They have to leave the room when the commission deliberates, and those things. There's some cases where there's sealed documents and the case, where they would have to leave. There's certain circumstances where they can't be in the room at all times, but that's very limited situations.
And those are pretty typical general rules of having press in the courtroom, a courtroom yes. of a type, right? Yeah, I understand.
Yes.
And so what about, so judges are subject to the canons, the code of conduct, right? The rules of professional conduct. Are there any limitations in those that would prevent judges from coming on our show or from being in the public like this?
Well, judges have given interviews in the past, and they just can't discuss pending or impending cases, and they can talk about, what they do as a judge and things that are important to them and their lives, and et cetera, but they just cannot discuss active cases that they've been involved in, or any other case for that matter.
Sure, and so I guess that was a question I did have. At what point, judges can never discuss, if it's a case they've had, they just cannot discuss it?
Well, if the case is completely over, the appeal period has ended, and there's no avenue for the case to be resurrected, and that could take many, many years, so the rule of thumb is they should not comment on cases that certainly are active cases. That's absolutely a no-no, and but cases even that are in the appellate process or could be in the habeas process. Those cases can be resurrected at any time. So the good rule of thumb is to avoid that, and they typically do.
Sure, but they can come on and speak on legal topics if we have questions about a specific area of law or something like that, or for instance, that would be something where a judge could opine on or discuss what the law is.
Well, yes and no.
Okay.
So a judge cannot, in answering questions, indicate that how they would rule in a case that would come before them, right? So they have to be very careful as how they can talk about the law. They know the law. They can talk about the law, and they can involve themselves in legal activities and pro bono activities, non-legal activities, extracurricular activities that it's often encouraged. But they just have to be careful that they don't take a position on certain matters that come before them and how they would rule.
So we have a couple of questions that have come in via Facebook that I actually would like to ask. So Sarah Hobart, she asks, does the commission use a standard for discipline similar to how the state bar uses guidelines to determine a baseline sanction and consider aggravating and mitigating circumstances? So is that something, when you guys are considering your recommendations, and the commission as well, is there sort of up factors, down factors that might, influence what the actual discipline may be?
Oh, yes. If the judge just came onto the bench and they're relatively new, that's certainly taken into consideration. If a judge has been on the bench for a long period of time and there was no discipline, the judge hasn't been disciplined, there haven't been any issues, all of those factors are taken into consideration. If there are aggravating factors, those are provided to the commission and in every respect. And as I said, it's a full picture to the commission. When they get a case, they're seeing everything, not just the complaint and the allegations, but through the recommendation process, they know how long the judge has been on the bench, what the disciplinary history of that judge is, if there were similar issues in the past concerning this complaint, and as well as if the case goes to an investigation or a response to the complaint, and the judge provides reasons why certain things were done in a certain way. Whether it be professional reasons, personal reasons, all of those are taken into account.
Understood. So another sort of a little bit of a different topic, but are there situations, this is from Albert Trevino from Facebook, are there situations where judges are both criminally prosecuted and subject to discipline by the commission?
Well, obviously the commission doesn't have criminal jurisdiction. That would be a district attorney's office. But is your question that is there cases where the commission has disciplined a judge and the judge has also been subject to criminal activity, subject to prosecution?
Yeah, so if there's discipline.
That question is yes.
Okay.
Yes. I mean, not often, but certainly that has happened in the past.
Hey everyone, thanks for tuning in to our Nevada Judges Perspective series with Paul Deyhle today. We just have a few announcements for you about what is coming up. Our Nevada Judges is having another Perspective series hosted by Marshall Willick about relocation. That'll be on November 6th at 1 o'clock. Make sure that you take a look at our Facebook page and our website for more information about that. Last year in 2020, our Nevada Judges partnered together with the Southern Nevada Association of Women Attorneys for 5 judicial candidate forums, and this year we're doing something a little bit different. We're partnering again with the Southern Nevada Association of Women Attorneys for a virtual legislative update panel series. Each of them are 1 hour long. That will be from November 15th through November 18th. There'll be lunchtime presentations. SNAWA also has its annual Miriam Shearing Gala coming up on December 1st. This year we are honoring Chief Judge Bell. The Clark County Law Foundation also has some events coming up. The first is the Liberty Bell Award ceremony. That is next week, October 28th at 3 o'clock p.m. It'll be a hybrid event. We will have our honorees, John Pirro and Augusta Massey, with us, and individuals who are supporting them. We'll also, with the partnership of our Nevada Judges, be broadcasting live on Facebook and YouTube, so we're super excited about that. The Law Foundation is also having its annual Attorney Memorial on November 5th. That is a private event where we are honoring attorneys by permission of their families who have passed in the last year. Lastly, we always want to make sure we throw out for trial by peers, our youth diversionary court. If you have a child that is getting into trouble in Clark County, be it in school or outside of school, parents and legal guardians of students in 6th through 12th grade, ages 11 to 17, can make a submission directly to the Clark County Law Foundation to request that their child be involved as a participant in one of our trial by peers restorative justice-based peer-to-peer diversionary court or ADR processes. Wow, that's pretty serious. And then another question we got from Megan Watson from Facebook. She asks, if a judge is retired, can they still be prosecuted by the commission?
Yes, for conduct that occurred while they were a judge. So the commission does retain jurisdiction for conduct that occurred while being a judge, even though they're retired. Now, there is a statute of limitations that the commission has to abide by, and that statute is 3 years or 1 year. So the commission has jurisdiction over complaints that have been filed within 3 years of the conduct occurring, or 1 year after a complainant knew or should have known that the misconduct occurred. So it's a dual statute of limitations process And there's some exceptions to that, whereby if it's a pattern over a number of years, for example, if the judge is doing a number of things, did something inappropriately, over the 3-year period, but that those activities continue up into the present within the statute of limitations period, then the commission does have jurisdiction because it is then a pattern of misconduct. But one of those activities have to fall in within the 3 or the 1 year statute of limitations for the commission to go forward. And I will say there are some commissions around the country where they have no statute of limitations. So complaints can be filed 20 years after the fact, presumably. But in Nevada, there is a 3-year and a 1 year statute of limitations.
We have a comment on YouTube now. GN from YouTube asks about the canons and the rules. So they asked, are the judicial canons or other rules that judges are required to follow in the Nevada Constitution, or were they created by some other process? So where are the judicial rules at, and how they come about?
Well, they're in the Constitution, they're in our statutes, they're in our procedural rules, and also through case law. So, the Constitution, we were created by the Constitution. Article 6, Section 21 is the section on the commission. And the legislature also enacted over decades statutes governing the commission and what we do and what we can't do. And then there are procedural rules, again, that the commission follows. And then lastly, there are the Supreme Court cases that interpret those laws and provide, further guidance as well as limitations on what the commission can and cannot do.
What would you, I'd love to, know more again about like what it is that, as you are overseeing all these judges, what are judges doing that you guys are seeing that you don't want them to do? You know what I mean? What kind of complaints will come before you and you're like, please just don't do this, and you just want, we've got a lot of new judges, so what should they know so they're not getting letters of caution or getting complaints?
Well, that's a loaded question.
Sure it is.
It's such a wide range of things. I mean, the Code of Judicial Conduct has 4 canons and a number of rules that fall under each canon, and they range from demeanor in the courtroom to competence following the law, ex parte communications where you're not talking to one side without both sides being there. There's Canon 4 is devoted to campaign and election violations. There's rules and canons on extracurricular activities, what they can do, what they cannot do. So it really is a wide range. I mean, the letters of caution are for many things, primarily minor. I mean, if it's a serious issue, it's going to go forward in the process. If it's a minor issue, then typically at first the judge would get a letter of caution. Just to, again, it's just an acknowledgement, some guidance to the judge saying, hey, the commission found this in the case, and please be mindful of that in the future. But as you said earlier, if the conduct continues, then it may get further in the discipline process the next time. I would say, one of the things that the commission finds quite frequently is not issuing orders on a timely basis. And that's something that the commission will issue letters of caution for initially. But sometimes, there's many months or even years before cases or orders are issued. And that, I would say, is probably one of the most frustrating aspects of what the commission sees, because, when you have a hearing or, you're issuing an order after motion practice, it should be done fairly quickly. But, judges are very, very busy. There's a lot going on. They got hundreds of cases, and it is very difficult. And the commission certainly understands that and takes that into consideration. But nevertheless, there's litigants that need finality to their cases. If there was a hearing, if there was a motion filed, they should get an order in a relatively, short period of time.
And I do know, I have heard myself as a practitioner and in my role with SNAWA and different things, with the judges, I know it's very important to them to try to do that because, of course, as you say, it's important for us practitioners and parties to have an order in place so that way we can, move forward and do what we need to do next, if anything, related to matters.
Now, I will say there are certain, during the investigative process, if we reach out to the judges or we want a response to the complaint, there are a number of reasons that would lend itself to why it takes so long for an order to be issued. And that could be by virtue of the attorneys filing multiple motions, and they keep filing motions, and the judge isn't able to issue the order on a timely basis, and that happens quite frequently. But there's other times where the attorneys are waiting for an order after a hearing, and it takes months and months and months. But by and large, I think the overwhelming majority of judges in this state at all levels, they do the best that they can. They take their positions seriously, and they try to get those orders out as much as possible. But there's a few judges that don't do that, and the commission has to deal with those situations as warranted.
Now, since members of the public can file complaints with the commission, but the commission is not the place for the public to come and say, I don't like the ruling that the judge made, right?
That is correct, and this is something I really wanted to touch on today, and what a lot of, I believe, people don't appreciate or understand about the process is that the commission cannot intervene or change an outcome in a case. We simply don't do that. We cannot change outcomes in particular cases. We do not have jurisdiction over decisional matters. So if you're involved in a court case and a judge makes the wrong decision in your mind, your remedy is to appeal that decision. We cannot. So 95% or thereabout of cases that the commission receives, are dismissed on jurisdictional grounds. That's not to say, it's not a question of the commission decided we're not going to discipline this judge for that. That's not what it is at all. We simply do not have jurisdiction over decisional matters. You have to appeal, and that is by law. And that percentage, that 95% dismissal rate, is the same dismissal rate and is consistent with judicial commissions throughout this country. We're not the only one that has such a high dismissal rate on decisional issues, and that's just the law. It's nothing else. We have to follow the law, and I know it's very, very frustrating for complainants, litigants to believe that the judge made the wrong decision, and they want action. They want the commission to do something, and when the commission doesn't do something because they can't do anything about it on jurisdictional grounds, they get very upset. We understand that, but there's really nothing that we can do if you are filing a complaint that is attacking a decision that the judge made.
Right.
Now, there are a few exceptions to that rule. Those that involve fundamental rights and persistently not following the law or complying with the law. There are 4 recognized exceptions to that rule, but by and large, 95% of the complaints fall within that, do not fall within those exceptions.
Sure. And so the purpose or the way to get a decision reversed or decided, you have to move it up into the court system. You just got to go up the Court of Appeals and the Supreme Court. So I guess as a practitioner, sometimes I go into court and I feel as though it's very obvious that the judge has not read the briefs and feels that the judge is not prepared, and that the judge has not, looked at what is really going on. In situations like that, is there anything, what can practitioners do, if anything?
Well, you can file a complaint. You can do that with the commission, bringing this to the commission's attention, and the commission will review it and possibly investigate if the commission decides to do so. We'll pull transcripts and whatnot. Those cases are very difficult, right? Because we don't know. Attorneys may know, they know their cases like no other. Are there judges out there that don't prepare? Yes, unfortunately. And as attorneys appearing before those judges, you know whether they've reviewed a case or not, but it's very difficult to prove that. The judge says, yes, I reviewed the case and I chose not to discuss this issue or that issue or what have you. And it's just to be honest, it's a very difficult case. If that's the only allegation of misconduct, it's very difficult for one of those cases to move forward in the process unless it's pervasive over many years, and you can show. But in one case, in one motion, the judge wasn't prepared, didn't know what I was talking about. I can, just to be honest, it's very difficult for that to move forward in the judicial discipline process.
So you had, oh man, so I guess it sounds as though, it either has to be something that maybe you saw all day long, you sat in their courtroom all day, and or you've been in front of them a bunch of times and it's clear that maybe they're not preparing each time.
If the judge is not reviewing things properly, not doing his or her due diligence in a case, and it leads to a erroneous decision in your mind or in a complainant's mind, then you have obviously you can appeal. If a judge is not considering evidence and it leads to certain decisions, which they often do, then the attorneys or litigants would have to appeal that, and presumably that would be taken into consideration on the appeal, that the judge didn't comply with the law. Given the facts, there's various, there's an avenue to remedy that, but not so much with the commission in that circumstance.
So, I think about, the rules of professional conduct. We have to maintain our competency. We have to, make sure that we're abiding by CLE requirements and all of those kinds of things. And so judges are still required to do that, yes?
Yes.
Like these instances of, I know lawyers, we have to keep up on how Facebook works, how YouTube works, sort of the things like that are coming up in different cases and stuff like that. Judges are being required to make sure they're keeping up on those things as well?
Yes, they have continuing legal education requirements, just like any other attorney does. And there's various educational opportunities put on by the Administrative Office of the Courts. The National Center for State Courts has various seminars that judges can go to and participate in that deal with their jobs on the bench and their responsibilities in the law. So there's many opportunities to be on top of what judges do and the laws and procedures.
Is there any kind of specific training that judges get once they go on the bench? Most of these are lawyers before they go on the bench and then they're elected. So it's a whole different job being a judge. What kind of specialized training do lawyers get once they become judges?
Well, I believe they have a course that a mandatory course that they have to attend when they first become a judge. But I believe that's it, and I don't remember exactly what that is, but once you are elected to be a judge, then you go to this course where they go over a number of topics and issues, and then you go forward in your duties. As you know, that in the smaller jurisdictions, some judges aren't attorneys, which presents more challenges in certain circumstances.
Sure. Does the commission do any presentations to judges once they're elected to the bench to, give them insight into what they should and shouldn't do?
Oh, yes. I've spoken throughout the state at various conferences and symposiums and on a number of issues on judicial misconduct and the judicial discipline process, much like I'm doing here today. So yes, they have many opportunities to attend these, not just in Nevada, but nationwide.
So we've got some more questions from the Facebook. One is about sort of once the decisions have been made by the commission, if the commission has imposed discipline against the judge, is there like a process to overturn that decision? Is there then like an appeal process from there? Mike Doty sort of spurred that question.
By law, complainants, those who file complaints with the commission, do not have appeal rights. But judges do. So if a judge is disciplined by the commission, the judge can appeal to the Nevada Supreme Court, and the Supreme Court can affirm the decision or reverse the decision. But complainants do not have the right to appeal. So it is final for them, whatever that decision is.
Interesting. And is there I'm curious to know if there's a reason that you know why there's that distinction?
Well, as far as I know, I think it's just it's the process. It's providing finality to the case, and I'm sure it has a lot to do with budgetary issues and fiscal considerations and the length of time of cases continuing in the process. Again, when judicial commissions such as ours were formed in the late 60s, the late 70s, a lot of these issues were discussed by the American Bar Association, by commissions and states for decades. And I believe that the process is very important. How long it takes, giving finality to cases and the process and money, budgetary issues, et cetera. But they've been in place for decades.
Sure, no, I understand. So you mentioned some budgetary issues that sort of is a good segue into another question we got on Facebook from Megan Watson. She asked about what is the impact of the commission's budget on prosecuting and investigating judges? So does money limit the ability to do things?
Oh, absolutely. That we're a relatively small agency in the state of Nevada. We're one of the smallest agencies. We have a small staff, small resources, and we're charged with doing a lot with relatively little. And so it's always a challenge. And if you look at our annual and biannual reports, and you follow some of the proceedings before various agencies, the money agencies before the state, it only takes a few cases, public cases, for us to be running out of money. So, we would have to request additional funds to continue. So budgetary issues are very, very important for the commission, and does hamper our ability to prosecute cases.
And when you say you have to apply for more funding, where are you applying for the funding?
The Interim Finance Committee, which is a committee of the legislature during, not during the legislative session, but off session. And if we forecasted that we were going to run short on money, then we would go through the process of getting additional funds from the Interim Finance Committee. And there's a whole process that occurs to do that. And, it takes time, it takes staff time and resources, and ultimately it's the IFC's decision to do that. And thankfully they have approved those requests in the past that allowed us to continue prosecuting cases and investigations. Otherwise, we would simply have to stop.
We definitely do not want that at all. Is there, I guess, a way for? Is that the only source of funding, I guess, or is there other avenues that even the commission can seek other funding, or is it just from the legislature?
Just from the legislature. We're a general fund agency. We do not receive grants or any other money from any other sources. Just a strict general fund agency. So
how, I guess this leads us into another question that we have. So some of the disenfranchised public believe the commission's not willing to prosecute judges based on a response to a single complaint. And, with how the budget sort of plays into that, how would expanding the commission's funding and resources impact its ability to operate? And is there a way to do that?
When you said some believe that the commission's not willing to prosecute a judge based upon the filing of a single complaint, what does that, if you can expound upon that?
Sure. I mean, I think that it's just a matter of certain members of the public are, and you even mentioned to me that, well, one instance may not quite be enough, but you also mentioned that there are some instances that are so serious that they would warrant, moving forward. I guess, where do all of the, pieces fit together, especially when you're thinking about the budget as well?
We've received single complaints that have led to the removal of judges from the bench. As you can imagine, one complaint may contain various allegations and violations of codes and canons. So, but the commission often, those cases that have gone public where judges have been disciplined are often the result of one complaint. And there may be other complaints that are consolidated into that complaint, but typically it's one complaint. So I would have to disagree that the commission doesn't want to discipline a judge on the filing of one complaint. But as I said earlier, it really depends upon the severity of the judge's actions. If it's a timeliness issue and the judge is not getting orders out or not writing written orders on a timely basis, and that goes to the judge's due diligence on the bench, and that is part of the code. But typically, the commission would initially issue a letter of caution. But if it is more serious, if a judge is stealing money from the public or acting very inappropriately on the bench in certain circumstances, that can and has led to a severe discipline of judges, including removal. So it really I'm trying to emphasize that it really depends upon the allegations, and some are minor allegations. It might not be minor in the eyes of a litigant or a complainant, and we don't mean to diminish that in any respect, but we as a commission have to follow the laws and the rules and the precedent, which has been established by the Constitution, the statute, as well as court precedent, the Supreme Court. We can't just discipline judges on every single complaint that is filed. There is a process. As you said earlier, there's aggravating circumstances and there's mitigating circumstances, and we cannot just, because a complaint is filed, that means that the commission doesn't want to prosecute them. And if the commission doesn't prosecute in a particular case, it doesn't mean that, there was nothing at all to the complaint. It just didn't rise to the level. We have a clear and convincing standard. It's a very high standard. We have to prove these cases. We can't just receive a complaint and then file formal charges. There is a process, and there is a legal process, and it's long. But I also, the commission is very mindful of the public, and there are cases and conduct that has occurred that should not have occurred. Judges should know the law. They should be diligent. They should be writing their written orders and issuing them on a timely basis, and certainly complying and following with the law. If you're a judge, that's your job. Now, there is a process. If they don't do that, mistakes are made. Just because a judge doesn't follow the law in one instance doesn't make them a bad judge. Every judge has had cases reversed, and it doesn't make them bad judge. It's just, and I can tell you 95% of the time, they learn from that, but
well, we're human, and judges are human too, right?
They're human, that's right. But I don't
human.
want to diminish the importance of filing a complaint with the commission by the public. The commission understands that and understands the frustrations. Oftentimes complainants will, they go to a hearing and the judge will take action. And they're so upset that as they're going home, they're on the phone with the commission. How can I file a complaint against the judge? And those are decisional issues. There's nothing that we can do. And if they don't follow the law in that one instance, they have to appeal. They're upset, and we certainly understand that. But those cases that are filed with the commission that we have jurisdiction over, that is misconduct, that's actionable misconduct. Those cases are investigated, the judges respond, and more often than not, than they are, formal charges are filed.
I want to get into sort of one last topic before we're running out of time. Gosh, I feel like I could talk to you for hours and hours. But sort of one last topic that we can cover for a little bit. Does the commission sort of face pushback from any other governmental agencies, the legislature, Supreme Court, into its investigations or investigatory powers and things like that? Have there been laws that have been enacted that try to limit your scope of powers, or anything that is relevant to you guys at this point?
Well, the existing laws that are on the books and the rules and Supreme Court precedent, those have the purpose of limiting what we can and cannot do, including the Constitution. So we have to follow those. But there are efforts during legislative sessions. Let me back up. During the judicial discipline process, the judges or their attorneys, they have certain rights to appeal decisions, which they do. There's motion practice, once it becomes public, where there are arguments made that they don't like this rule or that rule or this process. They think it's unfair, and that's all part of the process. You can make legal arguments and factual arguments, just like any other court. There's also rights to file writs of mandamus, prohibition with the Supreme Court in certain circumstances. So we have to comply with that, and the litigants have those rights to do that. But there's also efforts before the legislature, as you know, legislative sessions where bills are introduced in the legislature that want to further restrict what we do or define what we do. And, in those instances, in 2019, 2021, there were bills introduced to provide, to limit what we do and how we do it. And those bills were defeated. And so those are the things that the public really need to be, to involve themselves in and become aware of. Because it will affect, if some of these bills are enacted into law, it's going to make it more difficult for the commission to do its job. It's going to be more expensive to the taxpayer for the commission to do its job. It's going to take longer for the commission to do its job. And if the public wants to educate themselves on this process, they can go to the Nevada legislature's website and go both to the 2019 legislative session, which is AB 20, and they can go to the 2020 legislative session, which is AB 43, and they can look at all the exhibits and the testimony that were submitted during that process, and they can educate themselves on the issues and the public policy considerations and the fiscal considerations that all are in play with these bills, because they may very well come up again. And as you can see during this process and in the current and existing laws, there's a lot that we can't do. And it's not because the commission doesn't want to do it, it's because we can't do it. We have to follow the law, and that's what we do. So the commission is already very limited in what it can do. We have to stay in our lane, and we will. But additional bills coming down the pike may make it even more difficult for us to do what we do. And that should be very important to everybody in the public.
Sure. I mean, and us as practitioners as well, of course, with our clients and everything else. Because I guess what can the public do other than just getting educated? You say, about the bills and things like that. Is there any other way that the public or practitioners can support the commission to make sure that we still have it and it is able to actually function and do the job that it is supposed to do?
I would say, as I said, education is very important. Don't just read an article in the newspaper or online. You got to involve yourself in the process. Many times those articles, blogs are not accurate. Sometimes there's a lot of disinformation in those, misinformation, unfortunately, and cherry picking different things and characterizing it in certain ways. This shouldn't come as a surprise to anyone, but really just go and educate themselves, participate in the process, write letters to their legislators, and get involved in the process. I will tell you, that's the number one, that would be the most important thing, is to be aware of the bills that are being considered and educate themselves on the process. All of that information is at the Nevada legislature in the 2019 and 21 sessions. So there's everything there. You don't have to hunt for it. There's legal, there's the legal arguments, factual, opposing views, policy consider, everything is there, and that will, I would say, fill in about 90% of the blanks of what they need to know, and then the other 10% is just involvement in the process. Don't feel free to follow the process, contact their legislators, and voice their opinions. Even go to the hearings and request to be heard during legislative hearings, which the public has a right to do. That all makes a lot of difference in the process.
You mentioned there may be some bills that were coming that might be concerning for the commission. Are you able to say which ones those are?
No, I don't know, because I would say they're more of the same from AB 43.
Why don't you tell us, I guess, I elaborate a little bit on just what AB 20 and AB 43 were.
There was a lot involved in a lot of proposals, for changes to the statutes, et cetera. And, they range from changing the composition of the commission, bifurcating it into two sections instead of one, which is what the Constitution had authorized. There was changes to how or who, time limits for commissioners, the standard of proof on whether a judge should, I mentioned clear and convincing evidence, changing the rule, what that means. There was just a lot of changes that the commission believes would further hamper its abilities to do its job. As I said, it'll take longer, it'll be more expensive, it'll just erect more roadblocks to us doing our job. And as you know, we already have a lot of limitations on what we can do, and we do the best that we can, but the public has to be involved in the process, or it's going to be even more difficult for the commission to address judicial misconduct in the state. And I'm not saying that there aren't reasonable proposals to be made. There are, from the Discipline Commission, from the judiciary, from the bar, and from the public. There are, and we are open to those, and we will be participating in the Supreme Court's ADKT proceeding that will address potential changes to the Discipline Commission statutes, but also changes to the code. The Nevada Supreme Court has been wanting to revise the code for a couple of years now, and this presents a great opportunity in one ADKT proceeding to take a look at the code and as well as the Commission's statutes. And I believe that there are reasonable proposals to be made on all sides.
Sure. I guess in your opinion, now that we're at this place where it sounds like the Supreme Court is maybe looking at the Code of Judicial Conduct, what kinds of things might you want to see in there?
Well, I'm going to reserve that process. I'm going to wait for that process to play out. It just commenced, and we'll be certainly working on these issues in the coming months and year. And I'd be happy to come back on as that process plays out and have another interview, and we can discuss the issues. It's all going to be public and transparent, and we can, discuss the issues and the concerns, the positives, the negatives. So I'm more than happy to do this again.
Yeah, that would be great. I mean, certainly as we go forward. How long will that process take? You mentioned, I think you said a year. Is that what you guys are thinking of, trying to make your deadline to have this finished up with the Supreme Court?
Well, it's not necessarily, it's not our deadline. It's the Supreme Court has commenced an 80KT proceeding to address these issues. And by the way, they're addressing the issue with respect to the Judicial Commission because the legislature asked them to do so. They weren't doing this on their own accord, but by virtue of AB 20 and AB 43 being defeated in their entirety, but over the two legislative sessions, the legislature asked the Supreme Court if they would consider forming a commission to look at these statutes. So, and in so doing, they'll be looking at the Code of Judicial Conduct as well. So I believe that, I don't know off the top of my head exactly what that timeline is, but that's up to the Supreme Court, and it's going to cover at least till next year, I'm sure. And there's deadlines in public documents on when final reports need to be made. And again, I encourage the public to follow that process because, as I said before, very, very important changes could be made that could affect the judicial discipline process as well as the code. So engagement is very important. So
it sounds like there is already a committee or that is working together, and that process is beginning already. Is that?
It's in the process of the committee or commission members. They're in the process of being formed. So we'll be hearing from the Supreme Court in due course, once that commission is formed. And as I said, the proceedings will be public. It can be followed, and we encourage everyone to do so.
All right. Well, Paul, I mean, it's already 11:20, and man, I still wish we could just keep going and going. But we will go ahead and probably, if there's anything else you want to add before we leave today, what might it be?
I appreciate the time to discuss the commission and its challenges and its procedures and laws. And as I said before, I can talk about this for hours, and I just want to tell you that I'm more than willing to do another interview in the future and on specific issues. If I can comment on them, I will. But the commission and what it does is very important. And the more that the public is involved in the process, the more that the public is engaged in and knowledgeable of the bills that are being proposed, then the stronger commission will have and the more informed that they will be.
So if when the next session comes up, if there are bills that are concerning to you, would you be able to come on and talk about those at that time, or how would that work?
Yeah, certainly.
Okay.
Certainly. I mean, the bills are, once they're posted, people can read them, the public can read them, and all of the testimony and exhibits are public. So yes, I'd be happy to do that.
Okay, great. Fantastic. Well, I appreciate you so much. I know Alex and everyone here in the Worldwide Digital Broadcasting Studios appreciates you very, very much. And I hope that our public who has been able to view us today appreciates you. We got some great questions, so very excited about that. We will go ahead and sign off and thank everyone for coming today. Hey everyone, thanks for tuning in to our Nevada Judges Perspective series with Paul Deyhle today. We just have a few announcements for you about what is coming up. Our Nevada Judges is having another Perspective series hosted by Marshall Willick about relocation. That'll be on November 6th at 1 o'clock. Make sure that you take a look at our Facebook page and our website for more information about that. Last year in 2020, our Nevada Judges partnered together with the Southern Nevada Association of Women Attorneys for 5 judicial candidates candidate forums. And this year, we're doing something a little bit different. We're partnering again with the Southern Nevada Association of Women Attorneys for a virtual legislative update panel series. Each of them are 1 hour long. That will be from November 15th through November 18th. There'll be lunchtime presentations of bipartisan panels of members of our legislature, senators and assembly people from all over the state that will talk about the pieces of legislation that passed in our last legislative session and what maybe didn't pass and could be upcoming in the future. We do have 1 hour of general Nevada CLE credit for each of those, and registration is $25 for each day, or you can come and join SNAWA to become a member, and that will be $60 for the year, become a member for 2022, and join us for free. So for each of those days, we do have our panels confirmed. On the 15th, we've got Senators Joe Hardy, Dina Neal, and James Orenshaw, and we have Assembly people Chandra Summers Armstrong and Howard Watts. On the 16th, we've got Senator Nicole Cannizzaro and Assembly people Tracy Brown May, Brittany Miller, and Steve Yeager. On the 17th, we've got Senators Moises Dennis and Glenn Levitt, and Assembly people Leslie Cohen, Venetia Considine, Michelle Gorlow, and David Orenlichter. And then on the 18th, we have Senators Dallas Harris, Melanie Scheibel, Patricia Spearman, and Assembly people Lisa Krasner, Rochelle Nguyen, and Philip P.K. O'Neill. You can find out more about that on snawa.com or on facebook.com/snawanv. SNAWA also has its annual Miriam Shearing Gala coming up on December 1st. This year we are honoring Chief Judge Bell. Each year the SNAWA Foundation recognizes local female attorneys for their accomplishments and contributions to the advancement of women in the Nevada legal community. This year we invite you to join us to recognize Judge Bell for her outstanding leadership in designing and implementing the changes to the operations of the court to get us through COVID-19 this year and last year. Judge Bell was elected in 2008 and took the bench in January 2009. She was elected Chief Judge in 2018. This is an in-person event. We're hoping still will be held on December 1st from 5 to 8. It will be in the Regional Justice Center. We'll include a silent auction, short presentations, networking. All the proceeds go to the SNAWA Foundation Scholarship Fund, which provides scholarships for female law students at the Boyd School of Law. Registration is $60 per attendee, and additional donations are welcome. We really hope you'll join us to honor Judge Bell on the 1st. The Clark County Law Foundation also has some events coming up. The first is the Liberty Bell Award Ceremony. That is next week, October 28th at 3 o'clock p.m. It'll be a hybrid event. We will have our honorees, John Pirro and Augusta Massey, with us, and individuals who are supporting them. We'll also, with the partnership of our Nevada judges, be broadcasting live on Facebook and YouTube, so we're super excited about that. The Liberty Bell Award, since 1983, the Let Freedom Ring Committee has honored individuals in the community who have upheld the rule of law, contributed to good government within the community, stimulated a sense of civic responsibility, and encouraged respect for the law in the courts with this prestigious Liberty Bell Award. The Liberty Bell exhibit at the 5th Street School was the first phase of the Clark County Law Foundation's long-term Let Freedom Ring project that displays public art exhibits designed to reflect on significant moments in our jurisprudence along Lewis Avenue between the Regional Justice Center and the Lloyd D. George District Courthouse. This year, again, we're honoring Augusta Massey and John Pirro for their contributions, and they join the likes of last year's winners, Judge Karen Bennett Herron and Ogana Brown, prior winners, Judges Linda and Stuart Bell, Connie Ackridge, Justice Cherry, Commissioner Bonnie Bulla, Senator Reed, Justice Kadish, and more. We're looking forward to that, and we do hope that you will join us on October 28th at 3 o'clock. The Law Foundation is also having its annual Attorney Memorial on November 5th. That is a private event where we are honoring attorneys by permission of their families who have passed in the last year. Lastly, we always want to make sure we throw out for trial by peers, our youth diversionary court. If you have a child that is getting into trouble in Clark County, be it in school or outside of school, parents and legal guardians of students in 6th through 12th grade, ages 11 to 17, can make a submission directly to the Clark County Law Foundation to request that their child be involved as a participant in one of our trial by peers restorative justice-based peer-to-peer diversionary court or ADR processes. Our peer counselors are other 12 to 17-year-olds who have been trained and are supervised by volunteer lawyers and judges that are positive peer influences and have been to thousands of youth in our community who've been involved in situations like stealing, fighting, bullying, being out past curfew, trespassing, possessing drug paraphernalia or alcohol possession. We've handled thousands of cases over the course of our foundation's years, 28 years that we've been in Nevada. Students referred into the program are being held accountable for their actions by having to do community service, do essays and other classes, while they learn about the real-life consequences of what may happen if they continue down the path that they're headed. Our program administrators are also helping families with resource referrals if they need them and when a need is communicated. We really appreciate you guys watching, and keep on tuning in.